This week on Q&A, former Supreme Court Justice John Paul Stevens looks back on his 34 and a half years on the court and speaks about his new book.
Justice John Paul Stevens, you have a book. It's called a Supreme Court Memoir, but it's called Five Chiefs. Why?
Well, because it's a book about the Chief Justices of the United States, and the reason I've written about five is that I've had personal contact with five of the most recent five chiefs. So they're the five to whom the title refers.
Let me put on the screen a slide that shows these five names and the times that they were serving on the court. And it starts with Fred Vinson, right, who was nominated by President Truman. He served 7 years. Earl Warren, by President Eisenhower, served 15 and a half years. Warren Burger, about 17 years, appointed by Richard Nixon. William Rehnquist, by President Reagan, 19 years. And John Roberts, who's the current Chief Justice, by President George Walker Bush, 6 years. Start with Fred Vinson. What did you write about him?
Well, there are two parts of it, I guess. I haven't taken a second look at it recently, as I mentioned to you, but there's a discussion of his appointment, a little bit about his appointment, and about his work, partly through the observations of one of his former law clerks, Arthur Cedar, who was a classmate of mine in law school and remains a very good friend. As a matter of fact, we were born on the same day, so that we have a lot of reasons to be friends. But talking to Art gave me some things I thought would be of interest in the book. So I got that's one source. And a second source is my own experience the year ahead of Art's clerkship, when I was clerking for Justice Rutledge, and I had a few chances to come in contact with Chief Justice Vinson during that period. And so I've talked in the book a little bit about the things that I had personal contact with, and perhaps at a little greater length about some of the opinions he wrote, particularly in the year that I was clerking at the court.
What year did you clerk at the court?
I clerked on the October 1947 term. In other words, I went to work in, I think, sometime in September of 47, and I was there until I guess the end of June or early July of 48.
That year or so you were there, what did you take away from it?
I took away a lot. That's a wonderful experience, as other former law clerks can tell you. I don't cover all this in the book, of course, but I took away some wonderful friendships with clerks in other chambers, and I learned an awful lot about the law and about the working of the Supreme Court, things that are still pretty much the same, as well as things that have changed over the years. And it was a very rewarding professional experience.
How did you get that clerkship?
Well, that's kind of a long story too. Congress authorized a second clerkship for members of the court in the summer of 1947, if I remember correctly. And Justice Rutledge decided to hire a second clerk. And he was approached by two members of the faculty at Northwestern, Willard Wirtz, who later became Secretary of Labor, and Willard Pedrick, who had clerked for Vinson when he was a Court of Appeals judge. And they were persuaded, both Vinson and Rutledge, to take advantage of the opportunity to hire a new clerk pursuant to the statute, and they persuaded them that the two Northwestern graduates would be well qualified for those positions. And the two that were qualified were my good friend Art Cedar and I, who had pretty good grades at Northwestern, and they thought that both of us were qualified. And so they late in the spring, or I guess it was early summer of '47, they had a meeting with us in the law review office at Northwestern, and told us that they thought these two clerkships were pretty certainly available, and said they weren't sure which one should go for which job, and suggested they'd like us to make that decision. And as it turned out, the clerkship with Rutledge was available the following year, whereas the additional clerkship with Vinson was available the year after that, and was a 2-year requirement, whereas the Rutledge was just necessarily a 1-year requirement. And Art and I both felt we were ancient citizens because we had experience in the war, and were older than we thought other law graduates might have been before the war, and we're both anxious to get into professional work as soon as we could. So we both preferred the Rutledge clerkship, even though the Chief Justice clerkship sounds like it might have been a better job. So we settled it by flipping a coin, and I won the coin flip, and had the privilege of getting started with Justice Rutledge after the course. After we'd done the coin flipping and decisions, we still had to get the job, because it just was a question of what we'd apply for. But both Professor Wirtz and Professor Pedrick and other members of the faculty supported our applications, and I guess persuaded the justices that we were indeed qualified.
Now, did you have Willard Wirtz in class?
Yes, yeah, he was. I took labor law from him.
Your friend Art Cedar, is he still alive?
Yes.
Now, I got to ask, I mean, you've lived a long time.
Right.
91 years?
Yes, and a little more. And as I maybe already mentioned, Art and I were born on the same day. It's this very strange coincidence.
What have you two done that's kept you alive all these years?
Well, we've worked hard. We've exercised, and we've had good advice from our respective spouses, and we've had interesting lives and happy lives. That makes a big difference too.
Where does he live now?
He's in Charlottesville, Virginia, right now.
Go back to Fred Vinson. What do you remember about Fred Vinson? Was he a big man? Where did he come from? How did he get on the court as Chief Justice?
Well, he was not a big man. He was heavy. He was a heavy man. In fact, that's one of the incidents I think I've worked into the book, that on occasion when his messenger, who would usually drive him to work and back to the hotel where he lived, I can't think of the name of it right now.
He lived at the Wardman?
Yeah, the Wardman Park. Art would occasionally have to drive him home in his beat-up old Ford car that was several years old, and Vincent had a little trouble getting in and out of the car because he was heavy, and he remembered driving up to the Wardman Park, and the doorman, seeing his car, wanted to shoo him away, and until he saw that the Chief Justice was in the front seat, and then he'd greet them in a much more cordial way, and then Vinson would, with some difficulty, get out of the car and go home.
He was there 7 years as chief. Do you remember what significant impact he had on the court, and either how it ran or?
Well, as far as I could tell, it ran well. There was some feeling, I think, in the year or two before I got there and before Art got there, that there was some friction within the court. Particularly, Jackson was concerned that he didn't become chief himself, and there was some feeling that there might have been some antagonism between Jackson on the one hand and Hugo Black on the other. I never actually witnessed anything like that, but there's been a lot of writing about it, and I think there's some merit to it. I mention it because there was, as I say, there was this sense there might be some personal antagonism within the court at the time, but when I got down there, I found it entirely different. I remember at a Seventh Circuit conference in sometime in around 1970 or so, Thurgood Marshall came to Chicago, and in answering questions from the audience, he was asked about possible antagonism within the court, and he said, "No, we're all perfectly good friends. There's none of that." And I remember thinking to myself, well, that's for public consumption, but maybe it's not true. And so when I joined the court myself in 1975, I was sort of wondering whether Thurgood's story was accurate or not, and it was dead accurate. I should have known it. I mean, Thurgood is a very honorable person. In fact, one of the most trustworthy men I ever met. And it turned out to be true. I mean, when I got down, it was the personal relationships are really excellent, and that was true during my entire tenure.
What impact did Chief Justice Vinson have on Brown versus the Board of Education?
Well, of course, he was the chief while the case was, during the first arguments of the case and during the early deliberations, but he died before the court was able to decide it. So it's a little difficult to know exactly what his whole role in the decisional process was, but I think he was the chief when they ordered re-argument, and they ordered the lawyers to make rather extensive arguments on historical issues. They had quite a lot of briefing about the history of the 14th Amendment and what the attitude of the sponsors of the amendment were. And so he was, and a lot of that I think was suggested by Justice Frankfurter. And so I don't know just, who had what role in that as those deliberations developed. But after Earl Warren became chief, then they had an additional argument, and that's when it was decided, and it was decided in an opinion that really had very little to do with history.
I want to put on the screen some other statistics and ask you a question. When you retired from the court, I really wanted to ask you, I saw these numbers. Let's put it up there. These are the longest serving justices in history. There are 112 justices. William O. Douglas served the longest, over 36 years. Stephen Johnson Field served 12,614 days. You served 12,611 days. You were 3 days short of being the second longest serving justice in history. Did you know that?
I really didn't. I know people often ask me questions about whether I was trying to set a record or anything like that, and I really didn't particularly want to be remembered for the length of my service. And I never really paid much attention to it, because that's not necessarily a testament to the quality of your service or its importance. And so I didn't, but I was interested to learn later, and that I was close to Field. And I also been told or read somewhere that he really shouldn't get that many days, because for the last several months of his service, he was either sick or he wasn't able to participate in their work. So I think I may have even performed more time of active, constructive service on the court than he did.
Well, people that watch the court all thought you'd outdo William O. Douglas and become the number one serving justice.
Well, that would be, of course, I succeeded him, which is, and he had served much longer than I did, I think, didn't he?
He's about over 700 days longer.
Yeah, that's a couple of years.
When did you retire from the court?
Well, it was on the last, the day after the last day of not this last term, but the term before.
2010. So
2010, right.
Around June or July.
Right.
Yeah. The next justice that you write about is Earl Warren. And before I get you to talk about him some, let's watch this is a 1952 clip of him on the Longine Whitnauer program that used to run on television, black and white. Listen to what, he was the governor of California then. Listen to what he has to say about the world in 1952.
I don't believe that we can continue to travel the road to insolvency by piling up a national debt year after year in time of peace. There's always a day of reckoning, and I believe that we have to do that. I believe that we can, and that we must restore integrity in government and the confidence of people in the integrity of their government.
Well, he was a member of the Tea Party.
Yeah, he was a Republican governor of the state of California and was appointed by General Eisenhower to be Chief Justice of the Supreme Court. What do you remember about him, and when did you first meet him?
Well, my memories of him go back long before I first met him, and I really, I never had the kind of informal meeting with him that I had with the others that I mentioned. My first personal contact with him was the day I presented an oral argument to the Supreme Court, which I still remember vividly, because even though I had witnessed a lot of arguments as a law clerk and as a practicing lawyer over the years, when I got up to argue this case involving a Robinson-Patman Act issue that nobody would care about today, there he was. He's much closer than you appear to me now. I had the feeling that there he was right in front of me, and I have this vivid memory of being that close to the Chief Justice of the United States, which is an experience you don't forget. And as a matter of fact, I think I may have mentioned this in the book. I've talked about this with John Roberts and with Ruth Ginsburg and with Elena Kagan. And they all have remember the same sort of sensation at their first argument, and it's really a very memorable event.
What happened to the case you were arguing? Did you win?
No, I lost. I lost, and it's not an earth-shaking case, but they did decide a question of statutory construction under the cost justification defense under the Robinson-Patman Act.
Now, you served 34 some years on the court. What's it been like for you since you left? And why did you write the book?
Well, it's kind of a story that sort of grew by itself. When I left the court, I was invited to attend a fairly large number of informal sessions where I talked to smaller groups like the Rotary and groups in Arlington and elsewhere. And I was repeatedly asked, one of the questions that I always got was that you've served with 3 Chief Justices, tell us a little bit about how they were alike and how they differed. And it just stuck with me that people seem to be interested in the possible differences between different chiefs. And then I thought, thinking back further, I thought, well, actually, I've had some contact, not as intensive, with 5, and the idea came to me that there might be a fair amount of interest in talking about the chiefs. And in fact, I remember talking to John Roberts about the same time and saying to him that I thought the public did not have a full understanding of all the work the chief does. He has a fair number of additional responsibilities, and I thought it might be of interest to tell a little bit about some of the things the chief does that are different from what the other members of the court do. And also, the other side of the coin was, I wanted to make the point that when we are deciding the merits of cases, which is, of course, the most important thing we do, the 9 of us really are all equal. The chief has certain procedural responsibilities, but when you're actually voting on the outcome of a case, he's just one of 9. So both the interest in letting people know a little more about other work of the chief, as well as making the point that as an associate justice, I considered myself his equal on our most important work. I thought both of those thoughts merited sort of a discussion. And then as I got into writing it, different ideas came to me, and as I may have mentioned in other occasions, I enjoy writing. I like the work of writing opinions while I was a justice, and so this was kind of replaced a lot of that work what I was doing as an active judge. And so they grew like topsy, although I should say that I also have a section in there about the first 12 chiefs who came just as a background, and that was suggested by my agent on the book, suggested that would be helpful, and so I wrote that pretty much after the other parts of the book were put put together, and that is not a study in depth about the earlier chiefs, but sort of something to get the people who are not as familiar with the court as some scholars and some of the rest of us are, give them a little background that I thought might be of interest.
What impact did Earl Warren's 15 and a half years as chief have on the country?
Well, it had a tremendous impact. Of course, I think the most important case is Brown against the Board of Education, which he's famous for. I think he may well be responsible for producing a unanimous opinion. But as I suggest in the book, I don't think the unanimity of the opinion is as important as the result itself. And I don't think it would have been the end of the world if there had been dissenting opinions expressing views that were fairly prevalent in society at the time. And so I've never been one who thought unanimity was an absolute requirement. And often, as I suggest in the book, dissents will actually sometimes improve the quality of opinions because everyone knows then what arguments were considered and what the answers are to specific arguments. So I have never been one who thought that the unanimous character was the major achievement. The major achievement was the result itself, which I think was obviously quite clearly correct. And interestingly about that case, I think the decision is not the product of the history and all the historical research that Vinson and Frankfurt had requested, because I think a lot of that history suggests that the people who adopted and ratified the 14th Amendment did not anticipate or realize that it might put an end to segregated schools. I think the principle adopted required that result, but I'm not sure as a matter of original intent, if you look at that term, this is a case in which there's the actual intent of the draftsman is the same as the result that they produced.
You were appointed in '75 by Gerald Ford.
Yes.
You served under Warren Burger.
Yes. Well, that's one of the points of the book.
I know. Yeah, I'm sorry. I made the mistake. You don't serve under anybody.
That's exactly right.
Let me go to the clip of Warren Burger.
Everybody says that, and it's perfectly okay.
Served with him.
Yeah.
But let me show we did an interview. As a matter of fact, you talk about when he was chairman of the Bicentennial Commission on the Constitution, and we did an interview with him during that time. Here's a little clip so people who have not seen Warren Burger can see what he looks like.
We have, give or take, 1,500 in the federal judiciary, including magistrates and bankruptcy judges. There are very nearly 1,000 life tenure Article III judges now. Now, they are there because we need them, and we need more. Congress is constantly expanding federal jurisdiction, but we have to have more machinery to take care of it.
What was it like serving with Chief Justice Warren Burger?
Well, there are, of course, all sorts of aspects of it. He's a very likable man, and he was judged by others sometimes as being a little pompous and more regal than he might have been, but he was a good presiding officer. He was a very gracious public appeal. He handled public affairs very well. And the internal deliberations of the court, I think he was less competent than either of his two successors, to be frank with you. He did many fine things, but I don't think he handled the conferences as well as either Bill Rehnquist or John Roberts did, and I don't think he was as accurate in the assignment of opinions as he might have been. I think at times he assigned opinions to members of the court who didn't actually have the votes of four other colleagues on every issue in the case. So he was less than perfect on his work as a presiding officer in conference, But I think he was an excellent presiding officer in the public proceedings. I think he was very fair to both sides, and when there was a necessity for more time to make arguments, he would frequently allow a little extra time in arguing.
The part of the court that the public knows very little about is the conference.
Right.
Where is the conference room, and who's in there when you're discussing a case?
The conference room is just east of the courtroom, across the hall and back in the back of the building. And the people in the conference room during the conference are the 9 members of the court and no one else. In fact, whenever it's necessary for somebody to send a message into the court, they'll knock on the door, and the junior justice has the responsibility of getting up and answering the door. And Tom Clark used to say that he's the highest paid doorman in the country. That's one of your qualifications when you get there. And as I don't remember I put this in the book, but I remember my first, either my first or second conference, I was paying very close attention to the discussion as I remember it, and I failed to hear the knock on the door. And Billy Brennan on my left and Bill Rehnquist on my right both got up and answered the door. And it made me feel like I was about 2 feet high. And I learned from that one of the most important jobs of the junior justice is to remember that you're a doorman.
One of the things you do discuss in your book is the difference being in a conference run by Warren Burger or Bill Rehnquist or John Roberts.
Correct.
Can you explain the differences and how Warren Burger changed what happened in the court about how you participate?
Well, the change that I think he's responsible for, but I can't testify from personal knowledge or actual, but I'm quite sure that the change was the change in the order of voting that he made. That when I was a law clerk under Wiley Rutledge, he would talk about what happened in conference with his law clerks afterwards, and he explained that the case would be discussed with the Chief Justice describing the case, and then the justices talking about the case in order of seniority, explaining their general views of the case and so forth, until they went to the end of the line. But then the voting began with the junior justice and was followed in reverse order. And I know that was the practice when Rutledge was on the court when I was a law clerk. He showed us his notes about how it did, and he was the second to vote. Burton was the most junior justice. And when I got there, I was surprised to find that the chief not only discussed the case but also voted, and that's what happened. The order of voting was in order of seniority. And I can remember talking to Bill Rehnquist from time to time, because he was the second junior. The two of us sat next to one another, and we both exchanged the view that we preferred the earlier practice because it gave the junior justice, we felt it would give the junior justice a better opportunity to persuade our seniors if they had not committed themselves to a particular position. But then when he became chief, his views on that issue changed, and he went along with the other view.
Explain the difference between being Chief Justice, what their responsibility is, and an Associate Justice.
Well, the chief has the responsibility. He doesn't have to do it. He could just vote right away, but he states the case and what he thinks the controlling issues that need to be decided are before he explains how he would vote. So part of his role is he's setting forth the basis for the further discussion. And as I think I say in the book, but it's my memory in any event, Warren Burger was not as articulate and as skillful in setting forth the issues in a concise and unbiased manner as either of his successors were. And often when Warren was the chief, either Bill Brennan or sometimes Potter Stewart, who was particularly articulate — Potter Stewart was a really brilliant lawyer — would state the case all over again. and he would state the issues in a more neutral fashion, and then the discussion would proceed. But as I say, that's one of the things in which I think Berger was less skillful than some of the others. And I don't mean to suggest here that he wasn't a good lawyer. Berger was a very good lawyer, had argued cases in the court, and had been the head of one of the divisions of the Department of Justice after Eisenhower was elected.
You say in your book about Warren Berger that although he upheld the constitutionality of the death penalty, that he personally was against it?
Definitely, yeah.
And so was, who was the other?
Harry Blackmun,
Harry Blackmun.
the same way. There's no doubt about it. On many occasions, I heard him, in effect, say, this is not what I think ought to be the case, but it's a matter for the democratic process to decide. And he thought the role of the judge was obviously not to put forward his own views, but rather to follow what he thought.
Did he ever say that publicly?
I would assume he had, but I don't know.
And how often have you found that a justice will rule one way or write his opinion one way or join an opinion when he or she disagrees?
Oh, very
personally?
often. That's true of every member of the court on one or more issues.
Can you give us an example of when you did that?
It happened many, many times, but I just don't have one at the top of my head right now. But,
well, let's go on to.
I'll tell you one. Sure, the California, the case involving the enforcement of the federal narcotics laws against abusers of medical marijuana in California who wanted to grow it on their own premises. The question is whether, under the Commerce Clause, the federal government had the power to enforce that statute. And I thought it was quite clear, as a matter of power, the federal government could do just what it was thoughting to do. But I thought it was very unwise policy, and so that there's a clear mismatch between my policy views and my views of what the law was.
You also mentioned in your book that you and David Souter had an agreement that he would tell you when it was time for you to quit.
That's exactly right, and I think I may explain in the book. I'd had the same agreement with John Hastings on the Seventh Circuit, who was an excellent chief judge there, that he had asked me to let him know if I thought he was not delivering the same quality work as he had in the past. He, by the way, was also a man who wrote out the first drafts of his own opinions. And I remembered that when I went on the court, and when David came, I asked David if he would tip me off, because it's something I think every judge gets on in years realizes you have to appreciate the views of others on that issue. You're not the best judge of your own talent.
Did he ever tip you off?
No, he never did, but that's because that's one of the things that maybe triggered my retirement. He left before I did, so I didn't have his protection anymore. So I figured that was a serious breach of contract on his part to resign before I did.
You say that you sent a letter down to the White House in advance telling them that you were going to retire.
Yes.
How much time did you give them?
I don't remember. It's all a public matter, I think. I didn't announce that letter at the same time I sent it. I think that.
I don't remember, but
yeah.
I just wondered what.
I think sometime in June.
What triggered it, though? When did you remember the moment you said, "That's it, I'm getting out"?
Well, it was actually a process, and I was asked this in another interview recently, and I think I misspoke about the details, but. I began thinking of it more seriously as the years went by, and I think for I don't know how many years, I think on more than one occasion I may have mentioned to my law clerks that I should be giving thought to that, and did they have any suggestions, and they were very vociferous in trying persuading me that I should stay whenever I did raise it. And then I became, I guess maybe it was the year David retired, but the year before I did retire, I decided just to hire one law clerk. And that was publicly known, and so I was obviously seriously considering at that time that I would not, that would be my last year. But when I did that, two of my, I guess three of my then law clerks, 3 out of the 4 of them told me that if I changed my mind, they'd work for me in the following year. So I wasn't as though I'd made an irreversible decision. But obviously I was thinking seriously about it. And then I guess the event that really sealed the decision for me was when I didn't have to, but when I decided to announce my oral dissent in the Citizens United case. For some reason, I had trouble making the oral announcement. I stumbled with some of the presentation, which I felt was unusual. I had thought was reasonably articulate over the years before, and I became conscious that I didn't do a very good job on that particular occasion. And I decided then, I think I may have mentioned it to Steve Breyer that very day, that maybe I have to give a little thought to putting this to changing my career.
You still have an office in the court?
I do.
Have you sat on any circuit court cases?
No, I haven't. And one of the important bits of information about retirement that I learned from Jeff Memoir, the chief's the solicitor to the chief, was that I'm entitled to keep my chambers and my law clerk and my secretary, even if I don't sit on cases. But if I don't sit on cases, I will not be qualified for a raise in pay if Congress ever grants a raise in pay. And I'm not. I think the court is entitled and deserves better pay, but I'm not really going to lose any sleep over the likelihood that there'll be a salary increase.
Here's the 4th Chief Justice you write about, William Rehnquist. He was there for 19 years. Let's watch just from an interview clip of him.
Today, we do have a system called the cert pool, cert standing for certiorari, in which first 5, then 6, then 7, now 8 of the justices pool their law clerks to write memos about the 5,000 petitions for certiorari. That did not exist when I was a law clerk. My co-clerk and I, to Justice Jackson, divided up 1,200 cases between ourselves and wrote little memos to him in that way. And I think Justice Stevens, who is the clerk not in the cert pool, still operates that way.
Was that true? You did not operate as a part of the cert pool?
That is true, and the bill's description of it is exactly right. You might be interested in knowing that Justice Alito, although he was a member of the cert pool his first year, and I don't know whether second or third, has decided to operate independently, so that they're now, although for a while there were 9 members of the pool, there are only 8 again.
That was recorded some years ago, and there were 5,000 cases presented every year. Now there are 9,000.
Is that the number?
I think Chief Justice Roberts says there's something like 9,000. But have you changed your mind at all about how the cases are decided? I know that you talk in the book about the fact that there used to be a lot more cases argued, and that and I think it was Justice Berger that reduced the time to 30 minutes on each side?
I think that's right. That's right.
Because there used to be longer oral arguments, and you suggest in here that they ought to go back to longer oral arguments.
I think they should go back to longer arguments on a fair number of cases. I'm not suggesting that they should do it on every case, but I think that they're really for 2 different reasons. One is having a smaller docket gives you more time, and the time available for an argument is 4 hours in each argument day. It used to be 2 hours in the morning, 2 hours in the afternoon, and now they very rarely sit in the afternoon, and so they have the time available for them. And the second change is that particularly in cases with multiple issues that are rather divisive, there's an awful lot of time taken up with questioning. And I think that more time is taken up in questioning these days than it was when I first joined the court or when I was a law clerk. And I think so much time is taken up that sometimes the lawyers really don't get an adequate opportunity to say everything that they plan to say. And so I think that it would be, in those cases, more time would be more fair to the lawyers and more helpful to the court, and also that if the whole process would be approved. I don't think they have to do it in every case.
What about Chief Justice Rehnquist? What do you most remember about him?
Oh, well, there's many things that I remember about him. In fact, having watched the Redskins on this Sunday, I would think I would have won $2 from him.
You bet every game.
We bet on virtually every game. And we actually $1. We normally made $1 bet. It was very serious.
Who won the most?
Bill won a good deal more than I think I tended to let my interest and my desire about who should win influence my vote more than it should have.
What impact did he have on the running of the court?
Well, he was a more efficient presiding officer, both in the conferences and in open court as well. And I think perhaps he may have been too efficient in open court. He was very firm on when the red light goes on, the argument's over. And I think there are times when he might have been wise to give a little more time. But on the whole, he did an excellent job. He was totally impartial. He treated all litigants exactly alike, and they all had to watch the lights.
Well, you mentioned, when you're talking about that, a man that everybody knows on this network, a former Senator Arlen Specter.
Yes.
And that he tried to get a couple of words in edgewise when he was in front of the court?
Yes, he was arguing a case, just as representing a client. I can't remember the details of the case right now, and wanted to continue argument, but his time was up, and the chief insisted that the argument was over, and I think Senator Specter had never forgiven him for that.
Well, not only does he appear not to have forgiven him, but he also introduced legislation to try to force the court to go on television.
That's right. He believes very firmly that the court should go on television.
What was your reaction to that resolution that he was trying to get passed?
Well, that's a difficult issue. It is not one I discuss in the book. On the one hand, the televising the court would be good for the court and for the country, because I think people would realize that the justices are very thorough in their preparation for arguments and their understanding of the cases. They ask intelligent questions, and people, I think, are generally favorably impressed when they see the court at work. And so that's a very strong plus, and that's really, I think, what Senator Specter's primarily interested in. But the other side of the coin is that television often has unexpected and unintended consequences. And you're never 100% sure that might not cause a change in the procedure that would have an adverse effect on it. You mentioned football a little earlier. I remember going to a game, sitting in the stands, and all of a sudden the players are standing around for a minute or two. Why are they? Then you realize it's a commercial. The television has got their commercials in, so that it causes changes. And the televising of legislative proceedings, I think, has sometimes had an adverse effect on the quality of what goes on. So you're never 100% sure what the consequences of televising would be. And I think the members of the court, I think most of them feel more strongly than I do or I did, but I think they are very concerned that the televising might have an unforeseen adverse impact where both lawyers and an occasional justice might behave differently than he would if he was not being televised.
What is your guess as to what will happen over the years with television? Because, for instance, just yesterday when we're recording this, the Pennsylvania State Supreme Court made a big, had a public meeting where they went on television for the first time, and now all their proceedings are on television.
Well, and then I think Florida Supreme Court was one of the first to do that too. And I think basically the experience has not been adverse. In fact, they have a library, I think, in which lawyers can go look at prior arguments and learn a little bit more about the best way to proceed. So I don't, from what I understand, I don't think that to the extent it's been used in state courts, it has had the adverse effect that we consider. But I think one reason for that is that it's not the most popular program in the world. I don't think there's a tremendous audience for the everyday argument of every state Supreme Court decision that is argued. Whereas I think the audience would probably, at least in some cases, be larger if arguments of the United States Supreme Court.
Think it'll ever go on television?
Well, ever is a long word, but I wouldn't hold my breath, that's for sure.
In the book, you talk about the fact that Chief Justice Rehnquist had the 4 gold stripes on his help me out here.
On his robe.
On his robe.
Right.
What did you think of that idea? And did you ever tell him what you thought of that idea?
Well, I'm not 100% sure, to tell you the truth. He did, at one time, before he had his own robes decorated with the stripes, he did make a suggestion to all of us in an informal gathering that he thought that the robes that some foreign dignitaries had worn were very impressive, and we ought to give thought to it. And I think I remember, and this again, this is not in the book, but and perhaps I shouldn't even be saying it publicly, but I think I remember Sandra O'Connor saying that his suggestion reminded her of President Nixon's suggestion that he should have the military personnel at the White House have white uniforms, and she thought it was a very bad idea. And she also thought it would be a bad idea for the court to depart from the very conservative black robes that we've always followed. And I don't think the chief needs a special form of dress to identify himself in the courtroom.
What would be the legal isms of that? Could you have put 4 stripes on your robe if you wanted to?
I assume I could. I don't know.
Could the other justices have prevented the chief from putting 4 stripes on his robe?
That's an interesting question. I don't think so. I don't know. I suppose if we had felt strongly enough about it and as a majority asked him not to do it, he probably would have respected. But that's the kind of thing that each member of the court pretty much respects the judgment of the member who may be doing it, I think.
Who assigns him something as simple as an office? How do you get to choose your office?
Well, it's a little bit like asking who decided he's going to be chief. You know, a lot of these things just happened, and they've never been changed. It's been part of the practice and the tradition throughout the court. The first chief, I guess, was designated chief by President Washington, and that's been followed. But I don't think there's any law that would prevent the members of the Supreme Court from treating that office as other state appellate courts do, where they either rotate the chiefship 1 year after another, or they choose him by lot or something like that. So that I don't think there's a statute or a provision in the Constitution of which I'm aware that specifies that the president shall nominate the chief. But he's always done it. We've always been happy with it, and so nobody's even thought about it, as far as I know.
So, in your 34 years plus over there, how many different offices were you in?
Well, I was in 1, 2, 3, 4 different offices.
And you move according to seniority when?
No, well, yes and no. I first started in the office that I'm occupying right now, which is in a beautiful spot on the west side of the building, where I have a beautiful view of the Capitol. It is the office that was, as I understand it, was originally thought to be assigned to the retired Chief Justice, and Warren Burger did use it when he retired, but there was no retired Chief Justice when I joined the court, and Bill Douglas wanted to keep his chambers, and I didn't want to make an issue out of it, so I first moved into the location at the front of the court, and then I was able to leave that office and move halfway down the hall when Tom Clark died. He had chambers in the side of the court, and I went to his chambers for 2 or 3 years. And then when Potter Stewart retired, I moved into his chambers on the corner, which is a beautiful office. And I stayed there until they did the serious redecoration 3 or 4 years ago, in which all sorts of changes in the court were made. And when the justice's chambers remodeled, the justice had to take temporary quarters elsewhere. And when they remodeled my chambers, I moved into Justice O'Connor's chambers, and I liked them, so I just stayed there. And then I was there until I retired.
I counted, and I did it quickly before we started here, that you've served with 19 of the 112 justices.
Is that right?
Over the years. Yeah, and I guess, I don't know that this is a kind of question you want to answer, but who over those years were you the closest to, personally?
You know, it's interesting. I should have an answer to that question, and I've been thinking about it lately. I was very fond of Byron White. I was fond of all of them. But then I said, you know, I felt very strongly about Lewis Powell and Potter Stewart and Billy Brennan and Thurgood Marshall. They're all very, very good. Harry Blackman, we were all friends, and I think I was a genuine friend of Cassandra the same way, and David when he came on. And it's really difficult to elevate one over the other.
Well, you talk about sitting on the bench next to, as you say, Nino,
right.
Antonin Scalia, and there was one point where, I don't know whether I can get my notes or not, where, yeah, here it is, where he leaned over to you in the middle of an argument and said, "Must be dumb defendant day." Dumb defendant day. How often did you whisper those to each other?
Well, not that particular phrase, but Nino is a delightful guy. He's has a wonderful sense of humor, and you know he's very, very brilliant. So he comes up with things on very short notice. And there were more than one occasion when I was very happy to be a beneficiary of one or more of his remarks. I can't overstate how clever a person he is.
Here's your fifth Chief Justice, John Roberts.
Justice Brandeis once said he could do the 12 months worth of work at the court in 10 months, but he couldn't do it in 12 months. It's good that we get something of a break from each other. We have work that we continue to do. We continue to pour through those 9,000 petitions that come in. You can't put those off till the fall. You have to keep up with those. We get emergency matters from time to time, but we do get out of Washington. The workload is significantly reduced. Get to spend a little more time with my family than was the case is always the case during the sitting.
You said about Bill Rehnquist that he said, "Call me Bill," but you didn't. They would call him Chief?
We called him Chief. We really did, yeah.
What's the relationship? I mean, you're considerably older than John Roberts. What happens when a young man like that comes into the court?
I called him Chief. I still feel, if I see him today, I feel more comfortable calling him Chief than John. It wouldn't bother him in the slightest if I called him John, because we're good friends. But it's just one of those traditions and part of the court that sticks with me.
What's been his impact on the court? How has he affected the operation itself?
Well, he's continued to do a very fine job in handling the conferences. He's an excellent presiding officer. I think he may well be the best of well, I can't really evaluate Warren in that regard, because I know he was very highly regarded the way he handled public affairs too. But John is an excellent presiding officer. He's particularly good also in public affairs where he might have to be talking to a group of judges from a foreign country or paying a visit to the court or something and explaining what's going on there. He always would have something interesting to say about the history of the court that they could understand and appreciate. He's a very attractive person.
So what of all the 112 over the years, let's pick on the ones that you didn't serve with, who would you have liked to have known?
Well, that's a wonderful question. I guess the ones that come, the three that come most immediately to mind are the three that I regarded as heroes when I was a law student. Cardozo and Brandeis and Holmes.
Brandeis was the first Jewish member of the court?
Yes, I think that's right.
Because now I believe there's something like, 6 Catholics and 3 Jews on the court now, now that you've gone. Does it matter when people look at the court from the outside and they see that? Does that make a difference as to how people make decisions?
No, I don't think it does. I don't think it makes a difference at all, although at one time it was thought to be important. I mean, there was considered to be a Jewish seat on the court for a while, and that went from I guess I don't know whether Steve or Ruth has that now, but in any event, I don't, and I guess I'm the last WASP.
You're the last WASP.
And when I first came on the court, of course, most of the court over the years has been Protestant and white Anglo-Saxon, so that's true. But I don't think it makes a particle of difference. It really is totally irrelevant in the discussions, and there may be an occasion when a religious holiday is given particular significance by a member of the court, but other than that, it's totally irrelevant to the decisional process.
How did you do this book?
I did it the same way I write opinions. I had ideas and I'd write them out, and then I'd do more. And then when I got to a certain point, I asked my law clerk to read it over and make suggestions, and as my law clerks had done on my opinions, and I got excellent suggestions as I went along. And as I think I may have mentioned, my agent suggested the chapter about the earlier chiefs. But I wrote it, most of it at home, some of it in the office. And
I'm sure over the years you read the media copy on the way you made your decisions and whether or not Jerry Ford was happy with your political positions on the different issues. The question isn't that so much as, did you and President Ford ever talk about that in private?
No, never either before I was appointed or after I was appointed. He did write me a letter that I'm very proud of, that I've got on my wall, which generally indicates agreement with my judicial work, but I don't remember ever discussing any legal issue with him.
What do you want people, what's the thing you want them most to take away from this book?
From the book?
Yeah.
Well, I don't know. It's in a way, it's kind of a mishmash because it's a mixture of personal recollections and comments on different aspects of the law and different people. So I just don't know. I don't expect it to be valued very highly by scholars because it's not really directed at scholars. And I think perhaps there's some members of the general public will think I've got too much discussion of cases in there, and others may feel otherwise. It's kind of hard to say because it's something that just kind of grew as I worked on it.
Justice John Paul Stevens, we're out of time.
Great.
The name of the book is called 5 Chiefs. Thank you very much for joining us.
Well, thank you. You've been very kind to me.
For a DVD copy of this program, call 1-877-662-7726. For free transcripts or to give us your comments about this program, visit us at qna.org. Q&A programs are also available as C-SPAN podcasts.
Next, British Prime Minister David Cameron speaks at the Conservative Party conference. Then, Republican presidential candidate, Minnesota Representative Michelle Bachmann in New Hampshire. And at 11 p.m., another chance to see Q&A with retired Supreme Court Justice John Paul Stevens. Tomorrow on Washington Journal, Damon Moglen from the group called Friends of the Earth and Cindy Schild from the American Petroleum Institute offer their perspectives on a proposed $7 billion oil pipeline from Canada to Texas. Michael Malbin, executive director of the Campaign Finance Institute, examines 2012 campaign fundraising totals for this quarter. And Reuters agriculture reporter Charles Abbott discusses federal farm subsidy programs and how growers